also part of the best of our process, and I just want to express my appreciation to both of you for it. And thank you for being here for this morning. I look forward when Senator Brown has some questions that he wants to ask you this afternoon. We stand in recess until 2 o'clock. The hearing will come back to order. We are waiting for Senator Brown, who said that he had some questions of Mr. Blum, Mr. Von Raab. What I'd like to do is ask Mr. Mattingly.
He's on his way.
He's on his way, all right. Let me, prior to the arrival of Senator Brown, if I may, Mr. Blum, we ran out of time beforehand, and there was a lot of questions asked you in about 2.5 hours, 3 hours of testimony. I would like you just to, you talked about the foreign implications, you talked about the new money schemes and so forth that you have further information on and that's been developed in recent times. I'd like you to give us a sense of what you think, number one, the foreign policy implications are of this bank. What does this mean to the committee in general terms? And secondly, overall, I tried in my small way at the opening of the hearing to say what I think this means to people. What do you think it means to people? Why should people care about this?
I think the first message in this is...
You want to pull a mic up there?
The first and most important policy message is a straightforward one that we worked on for a number of years, which is the narcotics problem. This bank provides a worldwide infrastructure for narcotics dealers, and we're talking about cocaine, heroin, the drugs of choice in different places, and what this is a support system for crime on the streets in the United States and the death and destruction of a generation of children. And in that sense, it's an immediate domestic issue. In the larger sense, it has implications for democracy everywhere, because when you have a group of people running around the world corrupting fragile governments in places that are having a hard time, what you get is not democracy. What you get is a kind of mafia government. And that doesn't do anything for average people. It destroys the faith of people in democratic institutions. The issues with respect to development, the perversion of international lending schemes to support third world development, I think is another major foreign policy issue. And finally, there is an overwhelming domestic policy issue. I can't imagine why the United States of America would allow key people who are connected to the intelligence services of foreign governments to own a major bank in Washington, D.C. Banks are notorious places for the collection of intelligence. And when you own a bank, you can get to see the bank records of all the depositors. You get to see who's vulnerable. You get to be in a position to put money in the right places. And I think that's an aspect of this that hasn't been looked at. In other words, was this a political influence peddling scheme in Washington by foreign governments? We should know that.
Senator, may I just add one point to that? I know that the Congress has attempted to deal with this issue a number of times, and this case may give it a renewed basis for addressing it again, and that is there really is no effective international cooperative mechanism for dealing with international banking crimes. Each country has its own banking regulators. They don't exchange information. Once a bank transaction has left the shores of one country, whether it be in cash or whether it be by virtue of a wire or something else, that information is effectively lost to the regulators or the law enforcement people of the country from which it went. And I know that this steps right into the issue of banking as regulated or as managed by one country versus another, different privacy rules, and the fact that banking is central to business. Banking is also central to crime, and somehow the State Department, the Treasury Department, the Justice Department have got to get together in some way and get together with their respective pieces in other countries and work out some schemes in which we have effective law enforcement and regulation of the kind of international transactions that can lead to the creation of the BCCIs of this world.
Well, don't you think that the so-called Kerry amendments were an effort to try to force exactly that?
I was an internal supporter of the Kerry amendments. That's why I never testified on the Kerry amendments. I think that there are legitimate concerns about the Kerry amendments, but I think the balance of interest would have to support the Kerry amendments, yes.
Doesn't the change in the marketplace now, the rapid-fire transfer of trillions of dollars, the movement of capital so quickly between countries, the increasing relaxation of the lines that used to be both barriers as well as just demarcation points between countries, all of that's being erased now. So in terms of international law enforcement efforts, in terms of fighting lawlessness internationally, and the kind of thing we've seen, and we've seen whole governments taken over by criminal enterprise or nearly taken over in recent years. Banks, in the way in which capital is moved, are integral to that.
Absolutely.
Therefore, it seems to cry out, BCCI seems to say, boy, here's the example of how, if all of you want to maintain the sovereignty of your governments and the sanctity of your laws, you better have a means of cooperating and of having some international standards that people adhere to, or you're always going to have somebody out there who can support that. Is that accurate?
Yeah. And I watched the fumbling that went on when your amendments were being discussed and the administration was attempting to oppose them. And they were desperate even to get a level of cooperation in discussion that they could describe to the Senate. They weren't even coming close to getting a real level of cooperation in a practical sense. But the other countries were so unwilling to unbend and to open up some of their systems to us that even the preliminary discussions were almost fruitless.
Okay, well, we held you over here for Senator Brown. We have Federal Reserve waiting,
Right.
a number of other witnesses waiting, and we really need to try to keep things moving. So, Senator Brown, if I could.
Mr. Chairman, thank you. I particularly appreciate the opportunity to chat with these witnesses, and I might say I think I share with you shock at the kind of revelations that have come out today. Mr. Bloom, you reported incidents of people at the bank shredding documents that were under subpoena. Can you tell us who it was at the bank that was shredding the documents?
My information, which was provided by one of the people who worked in the Washington office, was that documents had been boxed in Miami, shipped to Washington, and that people had come over from the bank's London office and were systematically shredding them. I confronted the attorneys for the bank, and they said, no, it couldn't be, and assured me that was not the case. On the other hand, I now learn that many documents that we asked for then are suddenly being found piecemeal and haltingly. And it's taken Senator Kerry's staff years of badgering the bank to euchre out what remains of what wasn't shredded.
But can you tell us who it was who told you this story?
Yes, it's one of the witnesses whose names are blacked out in those memoranda.
So I take it that is available to the committee?
Yes, it is.
And I take it that means it's available to follow up on by Justice.
Absolutely, and it was given to Justice at the time. Well, it was blacked out because the man involved is not an American, is not living in the United States, and is in a country where this issue is extremely hot, and he has a genuine and well-founded fear for his life.
Did you pass this information on to the Justice Department?
Yes.
Who was it you told about it?
Well, where do we begin? I worked first with a series of Customs and IRS agents, Steve Cook, Bob Moore, Dave Burris. I talked to the U.S.
These
Attorney,
are all
the assistant
Customs agents, or
Burris is IRS, Cook is Customs, Moore is Customs. And I want to say, and I think the record should clearly reflect this, I've rarely worked with people of such courage and skill, and I was amazed, frankly, that some of them would stay on the job given the stress and the salary level and the things they were being asked to do. I have no fault at all with them.
Well, Mr. Chairman, the reason I want those on the record is I would assume one of the things that's going to interest us is to follow this chain where significant evidence
But then I also dealt with the assistants in the Tampa office. I dealt directly with Mark Chakowski, an assistant by the name of Rubenstein.
And they were advised of this destruction of evidence under subpoena?
They had, in fact, if you'll recall, there's the affidavit from Burris about the problem with the witness being asked to leave the country. So I would say that there was a real understanding there was an effort to tamper with this investigation.
But just to make the record clear, you conveyed that to these two gentlemen in the Tampa office, and as far as you know, they did nothing to follow up.
I have to say to you, I can't be precise as to whether the shredding incident by itself was, but certainly problems with the documents were. And I just don't recall at this point precisely what I told them, but they knew there was a serious problem with the investigation.
What about the two witnesses that were debriefed, I believe you said, in 1988? You mentioned that both Customs and IRS officials had received that information. Can you tell us who that was?
The two bank people who were debriefed. You have the identity of one of them. Both of them are under
I'm sorry, no, I
conditions.
meant the agents for the IRS.
Oh,
and
the
Customs
agents.
Service.
Again, it was the same people who set up the tapes and ran the tapes. And those tapes, by the way, have now been turned over to Robert Morgenthau, and I believe are under the grand jury material.
I meant the names of the agents.
The names of the agents, same ones. It was the same team.
Can you tell us the names of the agents then?
That worked on this, again, Bobby Moore, Dave Burris, Steve Cook.
The Customs agents who held up the plane to follow up on your source of information, do you recall any names of those people?
No, those were internal affairs, and what they wanted to know was how some documents had gotten into the hands of a network. And these were documents relating to the Noriega case, BCCI documents seized in London. And those guys were from an internal affairs unit, and I've forgotten their names. I wasn't taking notes. I wanted to get on with my vacation.
Sure. You mentioned letters of credit were issued with 12-point differential, which is, as you described, highly unusual and out of line. Can you give us an idea of who that was reported to?
That was material that was turned over to the U.S. Attorney in the Southern District of Florida by the attorneys for Lloyd's of London in the Bilbese coffee smuggling case. And what makes this significant is there is a lot of smuggling that goes on, and that smuggling, to get away with it, you need to paper your shipments so that people can't understand what's going on. If this place was churning out as many letters of credit as the records in that case suggest, this was a factory for assisting smugglers and assisting people who wanted to misvalue their goods and come in and show customs, hey, look, this is what we paid for it, don't bother us and try to collect extra tariff. And I'm sure Mr. Von Raab can tell you how significant and dangerous that kind of problem would be.
As far as you know, this particular practice was never prosecuted?
It wasn't. Indeed, Dexter Leighton, the U.S. Attorney for the Southern District, never followed up on the materials that were given to him.
You mentioned...
To my knowledge.
To your knowledge, surely.
Now, I will say that IRS, on its own, came in and went after one of the parties to the smuggling transaction. But the other part of it, the letter of credit part of it, that was brought to the U.S. Attorney's attention was never followed up on. And I believe the statute of limitations may by now have run on some of that.
In this process of reviewing, which is really an in-depth process that you've been through, were there reports that that had recommendations with regard to legislation that might be helpful in this?
Well, I didn't at that time generate reports other than help draft a committee report, which was issued, that had significant legislative recommendations and policy recommendations. And that report, of course, is a committee document, and I'm sure bears rereading, because I think it will hold up in light of what's being disclosed, as being a not bad piece of work.
I can't recall if it was you or Mr. Von Raab who talked about third world debts.
I did.
A potential scam in that area. Can you give us specifics with regard to countries?
Well, I'm reluctant to do that because what I've heard there is not of my direct knowledge, and I think it needs to be fleshed out more. The country that has been mentioned to me is in Latin America. I don't want to go beyond that. I'd be happy to do it in a closed session, but I think it would create unnecessary further turmoil, and at this point, to name it publicly and not have a hard backup
Sure,
material
no, I
for it.
appreciate that, and I'm sure we would also appreciate that information in closed session.
Certainly.
I'm going to say, can you give us the names of the people at Justice that you had passed this information on to? At least my recollection is you mentioned.
I will say again that the people I've named are the ones who I dealt with. I think the question of third world debt is not one that I've discussed with Justice. That's come to my attention more recently from other people. And frankly, Justice certainly hasn't sought me out. I've been available at all times, and I've offered to help.
I'd appreciate your evaluation of whether or not you think a cover-up was involved here, either by Justice or the Customs Service or of the Internal Revenue Service.
That's a very difficult question to answer, to make a judgment on. It's something that really has to be asked, though, and it has to be probed through. Without going into the internal processes of the Department of Justice, you can't really answer it. But I got to tell you, these cases should have been prosecuted. Somebody, given 1984, a man walks into IRS and he says, I'm dragging sacks of money around Miami. He gives them documents. He supports it. That man's name was Aziz Rahman. 1986, there's a money laundering case in Chicago. A Miami BCCI banker is convicted. Nobody links it up with the earlier report. 1987, you have the Tampa case, and you get that plea bargain, that god-awful plea bargain. You can go right down this list of warning flags and signals. And if you want to go through the banking end of it, the number of warning flags and signals on the ownership of First American, on the ownership of National Bank of Georgia. This case has been virtually dancing in public, and nobody's bothered to go track it down or see it through to the end.
On Aziz Rahman, I think
Yes.
you mentioned, can you tell me when that information was made available and to who?
Oh, well, precisely. We have a deposition. We deposed him. The information was given by him to the Internal Revenue Service, and all of that material, including a receipt for the data he delivered from IRS, is in a transcript of this committee.
Well, that should give us the specifics we need to follow up. I'm going to say
Senator, if I might just respond to your question, just to tell you, my exposure to customs agents today obviously is much different from what it was, but I still know a lot of them. I have never heard any of them suggest that there was a cover-up. And they typically would, if they saw it, they would comment and bridle, as it were. But a lot of them have suggested there was just no interest in the case and just a complete sort of going to sleep on the part of the higher level officials from whom they take their signals. I mean, whatever commitment agents have, they take their signals from the people for whom they work. And there was virtually no interest or encouragement that came from that level, which implies to me that there was a sort of lethargy of feeling good about things that just shouldn't have been there. But it's not, obviously not conclusive, but I have never been told by an agent that he or she felt that someone somewhere was stopping something. I think it was a question of not encouraging this thing.
But in light of some of the extremely inflammatory
Oh, I agree.
what I think is the inflammatory nature of some of this, aren't these the kind of revelations that would generate their own follow-up? I mean, you would almost have to take action to stop. I don't mean to lead you to conclusion,
No, I understand what you're saying,
but I think the question asks itself if
But there is a difference between a cover-up and getting an agency to move forward on something. Agents are necessarily looking at specifics, and agents, unless they feel their support at higher levels, are less likely to begin a broad-ranging investigation. I mean, the result of my problems with the Treasury Department by being taken out of BCCI, I can assure you, caused the customs agents in Tampa immediately to limit their scope. Because they realized, and it's not because someone told them to do that, but what they realized is that no longer was the fellow in charge going to protect them if they spent a few extra days chasing down something that didn't work, or if they got in trouble because they were pushing their own jurisdictional authority somewhere. They knew that was over. And so what they did was they dropped back and did exactly what they were told when they came to the office. And that's a big difference.
My colleague yield for one question. Did any agents, while you were there, reduce to writing their frustration and any memos?
Not that I saw. I'm not saying they didn't do it and it went somewhere or I didn't get it, but I didn't receive that.
One last question from my part. I wonder if you all could summarize for me the crimes, or at least indications of crimes, that could have been prosecuted that were not prosecuted because of the plea bargain agreement.
I'd start out by saying you had almost 2 tons of documents seized from a bank in Miami, Boca Raton, and Tampa, and virtually all of its business was in some manner or other criminal. That suggests to me that there are an awful lot of crimes in that stack, and that somebody should have been over them very, very carefully and been fishing them out and saying, we're going to move forward. But the most significant crimes on which the ball was dropped altogether are misrepresentations to the Fed, misstatements on audit papers delivered to regulatory authorities everywhere, falsification of all of the bank's books, aiding and abetting a variety of smuggling schemes which would make them co-conspirators, and then I think a wide array of other pieces of business, including bribery and other forms of corruption. A wide array of other pieces of business, including bribery and other forms of corruption. All of that was on the table. We're beginning to see how much there was. I just hope that people will insist you follow through and get to the bottom of all of that criminal activity.
Was there evidence of other money laundering schemes other than the one that...
You bet. You bet. Everything you touch with this bank, it's like every time you turn over a rock, all these things start scurrying around. It's like turning the lights on in a roach-filled kitchen. Everywhere. And I'll give you an example. We began to look at the papers that Aziz Rahman gave us. And this is early on. And there was a very peculiar thing, a $20 million deposit for the North Miami General Hospital. Well, that was in the Bahamas branch of BCCI, and it was paying a point less interest than the going rate. That ought to be a significant clue that something's very wrong. If you backtrack through the history of the North Miami Hospital, you find out that it was sold by some people, it was a charity, and they sold out to a Texas corporation. The rules are that when a charity sells its assets, it has to give the money to another charity. And here's the money sitting in a BCCI Bahamas account paying less than market interest. Was there a crime? You bet there probably was.
To give you an idea, even at the time of the arrests in October of 1988, there was unhappiness among the Customs Service at the kinds of charges that were brought at that time. because Customs felt that we could have charged people higher in the bank and we could have made stronger charges against the bank itself. But we were, I won't say assured, but led to believe that that would follow. Well, let's just get this done, we'll arrest these people, and we don't want to cause that problem now. So in effect, Justice acknowledged that with a small amount more work to fill some technical requirements, those greater charges against more important people and against the bank could be brought. Well, those were never brought, and those were then, in effect, I won't say prohibited, but probably covered by this plea bargaining agreement. The kinds of charges that Morgenthau brought in New York respecting money laundering are the same as could have been brought in October of 1988, October of 1989, October of 1990, and they weren't.
What's so startling, Senator, is that when this bank was finally seized, my understanding is they showed some $900 million booked in U.S. accounts. And this is 2 years after the plea bargain in Tampa, when everyone knew what they were all about. And I have to wonder what went on that enabled the bank to go out and tell the world that this was a minor problem, limited to a few people in Tampa, and that the bank had now cleaned up its operations. That's just an amazing development, given what we now know.
Hill & Knowlton is a very good public relations firm.
How did the plea bargain agreement jeopardize cases outside of, that could be prosecuted outside of that district? Or did it?
I don't know. I don't know the details or the technical side of it.
As I read the language, there's a prohibition on the use of material then known to the United States government. I understand the Justice Department argues that that's only limited to what was known to the U.S. Attorney in Tampa. As far as I'm concerned, that's splitting hairs. That kind of clause should never have been in a plea agreement, and there was no reason for him to accept it in the first place.
Thank you, Mr. Chairman.
Senator Jeffords.
And maybe you answered this. If you did, I'll look at the record sometime. You made the statement, I believe, that you didn't believe that in the Noriega excuse. And I wondered if you would elaborate on that.
Well, I just think that we brought information about Noriega to the department early, and the response was rather, we're going after the money launderers. We're going to hold back on subpoenaing the records of his bank accounts and his dealings and all the rest of it. Then, after the arrests and the indictments come January, we get to a point of now we're going to bring these people to trial and we're going to use them to make the case against Noriega. So the odd thing is, when there was a chance to get the evidence up front, they didn't take it. And then after the fact, they say the reason they don't go after the bank is because it's going to give them a shot at Noriega. I just can't put the two together.
We disagree on this point.
I know you do. That's why I got you.
There isn't a lot of disagreement, but I'm aware that the Noriega prosecution initially was very much opposed by DEA. DEA felt that Noriega had cooperated a lot with them, and Jack Lawn and Tom Kelly just could not believe that this guy was as bad as everybody said, and they questioned the witnesses and a lot of other things. So they weren't moving very smartly on that case, and they just were reluctant because they felt this was a fellow that had helped them in many respects. But once the case was basically accepted by the Justice Department, the Attorney General got behind it, and obviously the President as well. The DEA and everyone else changed their position, and at that point I think they became desperate to develop a good case against Noriega because they saw all this pressure coming down on them. And
Let me just ask you, I'm not contesting any of this. I don't know what
this
the
is all
thinking was.
speculation.
I agree, it's speculation, but the critical question is, if all of that is true, one would have thought there might have been superseding indictments, or you would have looked for a money laundering charge, or you would have looked to see, and there hasn't been any of that. Correct? Am I correct?
Yes, but I think they got conned by BCCI. They didn't get any good information out of BCCI. But the Noriega prosecution is a whole other issue. But I will say this much. It does give you an example of the kind of pressure that can be put on a case if the right people get involved. I mean, they really did jump on the Noriega issue for a while. But I feel, and I have some reason to believe from some of the agents, that the agents felt that the Justice Department looked at the BCCI case as a source of evidence.
Just my comment there, because I think this really underscores the kind of problem that's been discussed here. I was very much involved in the Noriega effort. I mean, this is the committee that first let people know in this country that Noriega was banking in America, money laundering in America, and so forth. And it was our hearings that created a lot of public view on this.
Well, I was the first federal official to get in trouble for being critical of Noriega, too.
Senator Helms. And Senator Helms was working jointly in an effort to say something ought to be done about this guy. Frankly, nothing was being done until the press picked up on what General Noriega and the linkages meant. Then you had sort of a public issue, and then it became a political necessity, not a public obligation. And it was because it was a political necessity that, as former commissioner says, people suddenly jumped on it. And indeed, I agree, it was a hell of a good example of what people could do when they put their mind to it in the span of a few months to make something happen. And something did happen. But unless it seems like there's that fire under it or something's happening, there doesn't seem to be that spontaneous sense of public obligation. And I think that's what both of our witnesses have been trying to underscore to us today. And I don't want to put words in your mouth.
No, that's fine. I agree.
Senator Simon.
Just one policy question. Within the next few months, Congress is going to be facing the question, do we take down the firewalls of Glass-Steagall that prohibit banks from getting into insurance and securities and other things? What do you, as you reflect on BCCI, would it be wise for Congress to do this? Can we learn something from this operation?
I think if you can get the Secretary of the Treasury to come before this committee and convince you that he understood what happened in BCCI, then you should do what he suggests. But if he comes before this committee and draws a blank, then you'll realize that the Treasury Department doesn't know what crime is. They only know what bank loans are.
Well, I think that there is a lesson, and the lesson is not only that it's very dangerous to play around with those firewalls, because you've seen that it's difficult enough in straight banking to keep track of what's happening. Now you see that where they're criminal and they're playing around with the books, it's even more difficult. Just add to the complexity of the institution, and the regulators will be totally swamped.
Without those firewalls, BCCI could have been in both the insurance business and the securities business.
Well, with all due respect, if BCCI had wanted to be in those businesses, it would be in those businesses anyway.
I hate to say this, it may have been. It turns out that Gaith Ferrone owned an insurance company, David Paul owned an insurance company. We may yet find out that despite firewalls, because various people were asleep at the switch, they owned it anyway.
Firewalls are only good for people who respect them. And the people involved in BCCI respected nothing.
Thank you.
Thank you very much. Gentlemen, I want to thank you. As I say, we're reserving the right, if we may, to recall you if subsequent questions arise or if there's follow-up by the members. There's a lot of material that you've laid out. As I said earlier, we wanted to start with a big picture. You've given us a big picture. This is not a narrow trail, but a very broad one. But I thought it was appropriate at the start of this hearing to really get a sense of what the record is, where it began, and where we're leading to. This afternoon, we have yet to hear from the Federal Reserve. There are some major implications about the currency and the First American Bank in Washington and so forth. We're going to recess for about 5 or 10 minutes so that we can vote, and we'll return as soon as this vote is over.
We'll continue with the afternoon portion of this hearing in just a moment. And a note that the subcommittee will meet again tomorrow, Friday, to hear from the head of a commission in Peru that has investigated the BCCI. We'll air that hearing tomorrow evening on C-SPAN. Be watching at 8 p.m. Eastern Time for scheduling information. From Washington, you're watching C-SPAN. We're taking a break now for information about upcoming programming and a note to join us Friday for our weekly Road to the White House at 5 p.m. Eastern Time. This week we'll hear from Arkansas Democratic Governor Bill Clinton, who spoke at the Alameda County Commonwealth Club in California, and we'll air an interview with the political editor of the McClatchy newspapers in California, Martin Smith. He'll talk about California politics and the 1992 presidential race. That's all on Road to the White House, Friday at 5 p.m. Eastern Time, 2 p.m. Pacific Time. And now turning to our upcoming schedule, next we'll continue with the afternoon portion of a hearing held Thursday by the Senate Foreign Relations Subcommittee on Terrorism, Narcotics, and International Operations. Members met to examine the implications of the collapse of the Bank of Credit and Commerce International, or BCCI. Just after that, it's a portion of the Young Americans for Freedom meeting Thursday. The seminar was entitled Victory Over Communism, Finishing the Job, and it featured a number of Republican representatives and policymakers. At 3:55 a.m. Eastern Time, 12:55 Pacific Time, it's the Rules Committee hearing held Thursday to determine a rule for debate of the highway bill in the House of Representatives. At issue is a 5-cent gasoline tax that would be used to subsidize the Highway Trust Fund for highway construction. Finally, join us at 8 a.m. Eastern Time for this week's edition of Journalists Roundtable. Our guests will be Karen Hosler of the Baltimore Sun, Jeffrey Birnbaum of the Wall Street Journal, and Stephen Roberts of U.S. News and World Report. They'll join us to take your calls on issues in the news. And that's a look at some of what's coming up on C-SPAN.
If you enjoy watching the House and Senate in action, then you should have Gavel to Gavel, a handy guide to the televised proceedings of Congress. Gavel to Gavel is the perfect complement to your viewing, with detailed, easy-to-understand descriptions of the legislative process. Gavel to Gavel answers the most often asked questions. Who controls the cameras in the House and Senate chambers? How do members register their votes on the floor? And how does the signal travel from Capitol Hill to your home? You'll find the answers and much more in the all-new 1991 edition of Gavel to Gavel. To receive your copy of Gavel to Gavel, send a check or money order for $3 to Gavel to Gavel, care of C-SPAN, 400 North Capitol Street, Suite 650, Washington, D.C. The zip code is 20001.
C-SPAN, the cable satellite public affairs network, and its companion network, C-SPAN 2, are privately funded to serve the public by America's cable television companies.
Next, it's the afternoon portion of Thursday's hearing held by the Senate Foreign Relations Subcommittee on Terrorism, Narcotics, and International Operations. Members met to examine the implications of the collapse of the Bank of Credit and Commerce International, or BCCI. The Luxembourg-based bank was indicted Monday in New York for bank fraud, and ongoing investigations have led to bank assets being seized in 8 countries, including the U.S. The Federal Reserve Board announced Monday that it will seek $200 million in fines against BCCI for evidence of secret deals between senior officials of the bank and some of its customers to purchase 3 U.S. banks. The witnesses in the afternoon session Thursday represent the State Department and the Federal Reserve Board.
Thank you very much. We have Mr. Virgil Mattingly, General Counsel of the Board of Governors of the Federal Reserve System, and Mr. William Taylor, the Staff Director for the Banking, Supervision, and Regulation section of the Board of Governors Federal Reserve System. Gentlemen, I'm very appreciative to you for your patience. This has been a longer day than we anticipated, and I think you can understand why, and I thank you for hanging in there. And we would like to invite your opening statements. I would ask you, if you have long prepared statements, if you want to submit them for the record and can summarize, I think it would be very helpful. And the full statements will appear in the record as if read. I would like to ask both of you if you would also rise so I can swear you as we are swearing all witnesses. Do you, Mr. Taylor and Mr. Mattingly, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. Who's leading off? Mr. Taylor?
Thank you,
very
Senator
much.
Kerry. Mr. Mattingly and I have filed a joint statement, which we appreciate your putting the record in its entirety, and I will try to summarize and shorten even
Without
by short.
objection, the full statement will be placed in as if read in full.
Thank you. Most of the background, I think, has been given on BCCI, and in our previous hearing, I think we've talked and discussed with the committee what actions we had taken leading up to the point of the more recent events. So what I would really like to do, if I could, is to skip that part and just go into the part commencing really since the committee's last hearing. By early 1991, information received by the Bank of England about BCCI and its activities raised fresh questions about the condition and integrity of the institution as a whole. In turn, the information prompted the Bank of England to commission Pricewaterhouse to undertake a special audit under the provisions of British banking law. The resulting so-called...
Had Pricewaterhouse done previous audits?
Pricewaterhouse had done previous audits, yes.
Pricewaterhouse was the auditor of record in the past?
Was the auditor of record as of the date it was appointed on this special. I think it started as the auditor with the statements of year-end 1989.
Thank you. Thank you.
The resulting so-called Section 41 report was completed and made available to the Bank of England in draft form on June 22, 1991. The Bank of England's filings in British courts indicate that the report disclosed evidence of complex and massive fraud at BCCI. It was the findings of this report that led to the decision by the authorities in the United Kingdom, Luxembourg, and the Cayman Islands to seize BCCI. The Federal Reserve was informed by the Bank of England on Friday, June 28th, that a near-term seizure of BCCI was in the works. In light of this information, the Federal Reserve promptly dispatched senior officials from the Federal Reserve Bank of New York and the Board of Governors to London, myself specifically from the Board of Governors, to begin the coordination efforts that led to the seizure of the BCCI offices on July 5th. The primary concern of the Federal Reserve was to take all reasonable and responsible steps to ensure that the seizure of the BCCI banks did not precipitate serious disruptions to the U.S. banking markets or in the dollar-based payments and clearing systems both here and abroad. Four factors loomed in the deliberations of the Federal Reserve in this regard. First, while BCCI's banking activities in the U.S. were small in balance sheet terms, a large share of its global activities were conducted in dollars, which must be settled in banks within the United States. Second, while the Federal Reserve was reasonably confident that the direct exposure of U.S. banks to BCCI was rather limited, we could not be sure that banking exposures in other banking markets or to other institutions might not cause disruptions in the interbank markets. Payments flows, and foreign exchange transactions. These could spill over into U.S. markets and to U.S. institutions. Third, there was also the danger that other banking institutions in the Gulf could come under pressure by virtue of uncertainties created by the BCCI seizure. And finally, there was a more general concern that the precedent of seizing an institution with operations in 69 countries could, by its very nature, unsettle banking markets on a global scale. By midday Wednesday, July 3rd, it was increasingly clear that the seizure would in fact take place on Friday, July 5th. The Federal Reserve informed senior officials at the state banking departments in New York and California. As the licensing authorities for the BCCI agencies in New York and Los Angeles, these departments, and not the Federal Reserve, were responsible for initiating actions to close these agencies. While the exact timing of the seizure of the BCCI banks had not yet been determined, the expectation on July 3rd would be that it was timed to coincide with the close of business in New York on July 5th. A special unit was established at the Bank of England to coordinate global regulatory actions and to provide a central point of supervisory information and advice. For several days, officials of the Federal Reserve Board and the Federal Reserve Bank of New York were stationed at the Bank of England to assist in that effort. A parallel unit focusing on payments and settlements issues, as well as activities in U.S. banking markets more generally, was established at the New York Federal Reserve Bank. This unit and a counterpart group at the board here in Washington were staffed 16 hours daily during the first week after the closure. Throughout the day of July 4th, the Federal Reserve maintained close contact with the Bank of England. Based on these discussions, it was still expected that the closure would occur on the close of business in New York, July 5th. On the evening of July 4th, however, the Federal Reserve was informed that the timing of the closure was being reconsidered due to legal issues that had arisen in Luxembourg. Over the course of the night of July 4th, it became apparent that the goal of effecting the seizure at the close of business New York time could not be realized. Rather than have the seizure occur during the business day, it was decided to accelerate the seizure so it would precede the opening of business in New York. This created a complicated task of getting the personnel and other arrangements in place in the early hours of the morning after the 4th of July holiday. It was accomplished without major problems or difficulties. Public announcements in Europe and the United States were coordinated at 8:30 a.m. New York time. The states of California and New York acted promptly. Bank examination personnel were fully deployed by 8:30 a.m., and the information clearing centers at the Bank of England and the Federal Reserve remained operational throughout the day of July 5th and over the ensuing weekend. Because of this cooperative effort among central banks worldwide, and because the Federal Reserve and state authorities had already acted to scale back BCCI's limited operations in the United States, the seizure of BCCI was effected on a global scale with virtually no adverse effect on U.S. markets. As a result of earlier regulatory action, on the day the U.S. offices of BCCI were closed by the states of California and New York, BCCI was funding its business in the United States basically from other non-U.S. BCCI operations, and as a result had very little exposure to creditors in this country. Although the exposure of this firm on a balance sheet basis had been over $1 billion some 2 years before, some 18 months before, by the time the business was wound down, the net exposure on the day of closure was less than $20 million. Mr. Mattingly will now discuss BCCI and will discuss how BCCI, how it was unable to obtain a substantial legal presence in the United States, decided to secretly control the shares of certain U.S. banks. I might just add here that what is significant, I think, and something that concerns us, as it did the former witnesses, is the fact that we consciously, from 1978 on, sought to avoid the presence of this company in this country, and the Federal Reserve at no time approved any application of BCCI to do anything in this country. And it is especially upsetting to us that they would do this illegally. Mr. Batty.
Senator Kerry, I too am pleased to be here today to appear before the subcommittee. I won't go over or rehearse the history of the First American matter. That's contained in our earlier testimony. I'll go right to the board's investigation and what that has uncovered. Yeah.
When you refer to your earlier testimony, what testimony are you saying? The one submitted today?
No, that is the testimony before the Subcommittee on Consumer.
Before the
Banking Committee.
When you testified before me in May.
Correct. May 23rd. Yes, sir.
I think what we'll do is we'll make that testimony part of this record also without objection.
Well, it's attached to our longer statement. Senator Kerry, as you know, on January the 4th, the board ordered a formal investigation into whether BCCI had illegally and secretly acquired control of the First American banks here in Washington in 1982, and whether false or misleading statements were made to the board by BCCI and others in order to achieve and conceal that secret control. This investigation, the board's investigation, built on prior inquiries that the board had conducted into a possible link between BCCI and First American. These inquiries had gone all the way back to the time of the initial application in 1981. A very significant development in the board's inquiries into this matter came in late 1990, when the New York County District Attorney, Mr. Morgenthau, with whom the Federal Reserve had been working, advised that he had received information from an informant that an auditor's report showed BCCI loans to CCAH shareholders. The Federal Reserve had been attempting for some time to determine whether those loans existed, despite having been told repeatedly and as late as 1990 by BCCI that it had not lent to acquire those shares. The Fed demanded access to the report from BCCI, and after some resistance, we were able to review a copy of that report dated October the 3rd, 1990, in London in early December 1990. The report confirmed the existence, this is a Price Waterhouse report, it confirmed the existence of over $1 billion in long-standing, non-performing loans by BCCI secured by the shares of CCAH. CCAH is the parent top-tier holding company for First American.
And it confirms, did it have a date as of what time, when that transaction was effective?
No, it did not. The report merely listed the fact that there were over $1 billion in loans going back some years secured by the stock. That review provided the Federal Reserve with evidence of a violation of the board's 1981 order, which approved CCAH's acquisition of First American on the basis that BCCI would have no role in that acquisition and would not fund the shareholders' acquisitions. The investigation has continued. The board thereupon ordered the formal investigation. That investigation has gone on for some 7 months now and has uncovered evidence of extensive and secret loan and nominee arrangements between BCCI and its customers. These arrangements were designed to allow BCCI to acquire, in the name of these customers, the stock of the First American Banking Organization, as well as 3 other federally insured depository institutions in this country. These arrangements, in many cases, most cases, involve sham loans to the BCCI customers with side agreements, which we have seen, with the customers, that the customers would not be required to repay or service the loans, and that BCCI, at any time it chose, could sell the shares and retain the profits. In return for the use of their names, our evidence suggests that the customers receive fees and indemnities. Most of these CCAH loans were never serviced or repaid except through other loans from BCCI. From the evidence available, it appears that through bookkeeping manipulations of CCAH stock and loans to repay or service loans, BCCI generated hundreds of millions of dollars in fictitious paper profits to cover massive losses in its trading and lending accounts. As a result of the information acquired in the early stages of our investigation, as soon as we had information about these nominee arrangements, the board on January the 22nd made criminal referrals to the Department of Justice and proposed a cease and desist order against BCCI. As issued in March, the cease and desist order had 4 principal aims. It required BCCI to divest promptly its CCAH shares according to a plan to be submitted to the Fed. It required termination of transactions between BCCI and the First American banks. It required BCCI to have sufficient liquid assets at its agencies in at its New York agency to cover liabilities in those agencies. And finally, it required termination of BCCI's residual business presence in the United States within 1 year, as quickly as possible, but within 1 year. In other words, the Federal Reserve decided that BCCI should leave this country. In connection with the investigation, the board has also taken steps to monitor through the examination process the operations of the First American banks. Events have made the requirement that BCCI divest the CCAH shares under its control more difficult. BCCI had submitted to the board 2 proposed divestiture plans. These plans called for a transfer, at our suggestion, of the shares of CCAH held by BCCI to a trustee acceptable to the Federal Reserve. The trustee would have complete control over that stock and would be directed by the trust agreement to negotiate the sale of that stock to a third party acceptable to the Federal Reserve as promptly as possible. At the end of that, the Federal Reserve would have given them a certain amount of time to negotiate the sale. At the end of the sale, the Federal Reserve would have been directed to hold could have directed the holding of a public auction on the stock. Implementation of BCCI's divestiture plans has, however, been delayed by the seizure of BCCI by the regulatory authorities on July 5th. After that date, the officers and counsel for BCCI were no longer able to negotiate or effectuate a divestiture of CCAH or the other bank stock that BCCI acquired. The July 5th seizure does not, however, void the board's divestiture orders. Those orders remain fully effective and legally binding. The seizure shifts the responsibility and the task of implementing those orders from BCCI to the receivers for BCCI. We have been in contact.
Let me understand that now for a minute. The receivers for BCCI, where?
This would be the receiver
Does that take us to London?
It would take us to Mr. Smuha, who has been, yes, to London and Luxembourg.
So you are now telling us that resolution of First American Bank shares lies not in our hands or our control, but essentially in control in another country.
No,
All right, that's why I'm trying to understand
okay,
that.
the board has an order outstanding, a divestiture order.
The board has an order outstanding, but the board cannot get its order implemented. Is that accurate?
We have asked for a plan from the receiver to implement the plan, to implement that divestiture order.
You cannot do it until you receive a plan from Luxembourg.
We have asked them for the plan, yes.
What would the date, do you have an anticipated date expected?
I have a meeting arranged with them. I have met with them already. I have been in contact with their lawyers.
Well, let me let you finish, then I'll pursue some questions.
We're going to meet again with them next week regarding this point. The receivers have stated in these meetings with us that they intend to cooperate with the Federal Reserve to achieve the divestiture, and our discussions are continuing. The board is also exploring other avenues to regularize the ownership of CCAH. We do have an effective order outstanding, and there are certain remedies available to the board to make sure that that order is enforced and carried out. The board's investigation of the BCCI matter is continuing and is the most comprehensive in our experience. As part of the investigation, the board is proceeding with enforcement actions as the evidence to support those actions is accumulated. Thus, on the 29th of July, the board assessed a civil money penalty against BCCI of $200 million. The notice covered the illegal acquisition of First American and two other banks, the National Bank of Georgia and Centrust Savings Bank. I should also note that the board earlier in July issued a notice with regard to the BCCI's alleged illegal acquisition of the Independence Bank in California. The board has also taken actions to bar permanently 9 individuals associated with this from any involvement in U.S. banking. At the request of the United States Attorney for the District of Columbia, the board has deferred temporarily the assessment of substantial civil money penalties against the individuals charged pending completion of the United States Attorney's criminal inquiry. Senator Kerry, as you know, as a result of the BCCI matter and other recent compliance problems that the Federal Reserve has had with foreign banks, the board has proposed legislation, recommended legislation, to strengthen the supervision and regulation of foreign banks in the United States. Those proposals were introduced in the Senate as S-1019 by Senator Regal, Senator Kerry, and Senator Garn, and are being considered as we speak by the Senate Banking Committee as part of the comprehensive banking reform proposal. S-1019 is intended to help assure that the important banking policies established by the Congress are applied to all bank operations in the United States, and that the sizable foreign bank community in this country adheres to legal requirements and operates in a safe and sound manner. One of the most important of those recommendations is a recommendation that no foreign bank be allowed to open additional offices in this country unless the Federal Reserve is assured that there is home country supervision for that bank. And that recommendation grows directly out of our experience with the BCCI matter. BCCI, at its apex, was a holding company. It was also a bank holding company, but it was a holding company, and it operated without a supervisor that could ensure consolidated supervision over the organization as a whole. The absence of supervision, of consolidated supervision, was critical to BCCI's ability to carry out the manipulation of its books and the concealment of its actual financial condition. In closing, I wish to point out that the board's legislative recommendations do not guarantee that BCCI problems will never recur. Fraud is hard for any regulator to detect, especially when the transactions are deliberately and intentionally structured to conceal relationships and when the relevant information is maintained outside the United States. The board's proposals attempt to address the potential for such illegal activities by creating a bar to U.S. entry by weakly capitalized, poorly managed, and inadequately supervised organizations. Thank you.
Well, thank you very much, Mr. Mattingly. Let me just say, because I think it's important that as criticisms are surfacing here and as questions arise about performance, I think it's also important to point out where there's been good performance and where people have been responsive. And I want to personally thank you, and I want to thank Chairman Greenspan and the Fed, who have been very responsive, who have listened to our suggestions and complaints. And the chairman personally has responded a couple of times to suggestions that we had. And I think they've been the right responses personally. And I want to congratulate the Fed for its recent efforts in this. I know the chairman was in touch with the Bank of England some months ago and was talking with them about the problem, and there were great questions about how to proceed. And I think you proceeded courageously and appropriately. There are questions, obviously, about who knew what when, and who should have known what when, and whose responsibility it was to do what when. And those are clearly on the table to a certain degree here. I think one also has to put all of that in perspective and balance it against the role of the Fed, what the Fed is really equipped to do and supposed to do, and so forth. The record is clear, and I concur with the record, that in recent years there has been a conscious effort over the years to prevent BCCI from being able to gain the foothold that it did gain surreptitiously. But there are other questions that I want to ask you in terms of this, and I'd like to begin one area and then I'll move over to another. Who, according to the Fed, owns First American Bank now? Who owns the bank?
The banks are owned by a bank holding company, First American Bank Shares. That stock is owned through a series of holding companies until you get to the top.
Can you pull the mic a little closer there again? Sorry.
I'm sorry.
It's just tricky. It's pretty direction-oriented.
The First American banks are owned by a bank holding company registered with the board located here in Washington, D.C. The holding company is called First American Bank Shares. First American Bank Shares is owned by a series of holding companies, 3 other holding companies. The top-tier holding company is called CCAH.
And who are the principals of CCAH?
It is the stock of CCAH that we believe over 50% of the stock of that holding company, we believe, is controlled by BCCI. We also know that 29% of that stock is owned and controlled by the government and ruling family of Abu Dhabi, one of the United Arab Emirates.
Now, when you so in effect, when you peel off the layers and work down the corporate ladder, in point of real control of who has the capacity to govern, is it fair to say that the government of Abu Dhabi owns First American Bank?
I would say that the government of Abu Dhabi, the government and the ruling family, the government and the royal family of Abu Dhabi have a control block. Yes, I would agree with that.
So the largest bank in Washington, do you have a correction on that, Mr. Taylor? Or?
No, other than to observe that I agree with Mr. Mattingly. However, I think if you were to ask those people and they were here, they'd say they don't have very much control at all in reality, in the sense of calling the day-to-day shots.
And the reason for that would be what?
Pursuant to the original board approval order in 1981, control of those banks was put in the hands of an American board of directors, the First American Bank Shares directors. That time it was Mr. Clark Clifford, Mr. Altman, Senator Stuart Symington, General Quesada, General Gavin. the representations made to the board that these Middle Eastern investors were only in this as a passive investment, that real control of the operations of those American banks would be in the hands of this American board of directors that I have described.
Now, in terms of the legal issues here and the rights of the Fed, so to speak, is there a legitimate distinction between legal control by shares owned and day-to-day control as it is exercised?
Under our statute, there is such a distinction, yes.
And can you clarify that for the sake of the committee?
There are two types of control. The first type of control under the Bank Holding Company Act is ownership or control over the stock of a bank. It is that which we believe BCCI has. The other kind of control covered by the Bank Holding Company Act is control over the way the bank does business, a so-called controlling influence test. Can this person cause the bank to do certain things or not do certain things? That is the control that, when the board approved the order, was vested in the board of directors, the American board of directors.
Was it vested in the board of directors with the knowledge that the bank would, in effect, by virtue of stock control, passive or otherwise, be in the hands of the ruling family and connections of Abu Dhabi?
Yes, at that time, the Abu Dhabi, part of the royal family of Abu Dhabi, I believe, was to own approximately 10% of the CCAH, and ADIA, the Abu Dhabi Investment Authority, was to own about 8%. So at the original transaction,
which took place in 1981,
it was consummated on April the 17th, 1982.
82.
The Abu Dhabi interests, I believe, had about, I can get you the exact figure, but it's about 18 to 20.
I think we'd like the exact figure for the record if you have it. I mean, you don't have to do it now, but it's 18 to 20%.
Got it right here.
Now, subsequent, I'll wait for you.
The Abu Dhabi Investment Authority had 8.24%, and then there was, it shows here, I'm sorry, 13.72% that was held by a gentleman named Abdullah Darwash, and he was holding those shares as trustee or personal representative for a minor son of the ruler of Abu Dhabi. So together, you have approximately 21, a little over 21, 22%. All of the, Senator Kerry, all of the...
Now, Darwash at that time was under house arrest, was he not? I believe. And this is the issue that came up in the course of...
Yes. On the date that the board approved the order, the board subsequently learned that Mr. Darwash was under house arrest in Abu Dhabi.
Okay. Now, subsequent to this purchase, a clandestine series of transactions took place. Is that accurate?
That's our information, yes.
And those specifically were what?
Well, they're the manipulation in the stock,
A series of loans were basically made by BCCI to individuals secured by the stock. And indeed, the terms, at least from what we can determine, the terms of the loans were such as to not make them loans at all, but really to cast them more in the light of a nominee holding. That's a layman's.
And in effect, because they were not serviced,
That
ownership was transferred. Is that the...
not just because, I should let the
Yeah.
No,
counsel
not just
answer that,
because
but
they weren't serviced, but
You know,
go
they
ahead.
were sham loans. I mean, in
Arrangements.
our view, what is alleged, the board has issued a 110-page indictment that describes the various transactions that occurred in that stock beginning in 1982. What's alleged in here is that there weren't loans, that stock was owned by BCCI right from the beginning, and loans there were loans made to individuals. The stock was registered in individuals' names, and fictitious loans were made to those individuals to purchase the shares.
And as a consequence of those fictitious loans, It is the judgment of the Fed Reserve today that BCCI, in effect, owns First American. Is that correct?
That is
That's correct.
what is alleged in this document is that beginning in 1982, they had at least 25%, which is legal control under the Bank Holding Company Act. And over the ensuing, they may have had more, but over the ensuing years, ending in 1989, they acquired, we believe they hold today, 60% of the stock of CCAH.
Well, one of the questions that comes up when one looks back to see what happened and when it happened, and the question is not, could BCCI lend to these individuals? There's nothing in our order that prohibited BCCI from lending to individuals for other purposes. But it was very clearly in the intent, in the original application, and it was the board's understanding when it approved this application, that they would not borrow from BCCI for the purpose of effecting this transaction. Not just because the loans were past due, but also because of other documents that were found indicating prior arrangement as opposed to straight debt.
I think for the benefit of the committee, if I could, in our prior testimony before the Banking Committee, there are listed out on pages 8 and 9 a sampling of the various statements and representations made to the Federal Reserve Board in 1981 in connection with that application. And one of them, I think, bears repeating. The application stated, BCCI owns no shares of FGB, that's First American, CCAH, or CCAI, either directly or indirectly, nor will it if the application is approved. Neither is it, BCCI, a lender, nor will it be with respect to the acquisition by any of the investors of either First American, CCAI, or CCAH shares. In our view, nothing could be clearer.
Now, Mr. Mattingly, Ms. Taylor, are you prepared to make available to the committee a copy of the Price Waterhouse report?
This is the Price Waterhouse report dated June.
The June Price Waterhouse report.
I would think.
I would think that if the Federal Reserve received a formal request from the committee, that would be given appropriate consideration, serious consideration.
Well, no.
Senator, I'm not at liberty to make that decision. That decision would have to be made by the board.
Can you tell me any reason why the committee, which is looking at this issue, shouldn't be able to see the report on which the judgment was made that massive fraud was involved?
The Federal Reserve received that report from the bank.
You guys don't classify things too, do you?
No, we didn't. We received that report from the Bank of England, and we received it under an arrangement from the Bank of England that we would have to notify them of any request that we received for access to the report. Now, I add
well,
that report.
I would take the liberty. We're a quorum here of the committee. I don't know how everybody feels, but I think we ought to see that report, and I'd like to request it. Does anybody disagree? So consider this a formal request of the committee.
Following, I would hope that we could submit that report.
Let me ask you another question then, and we will hope that you can submit it shortly. Have you or any of your investigative staff, Mr. Taylor, seen an alleged list of United States officials reportedly prepared by officials at BCCI that indicates payoffs or bribes in any form?
We have been hearing about this list for the last 3 or 4 weeks. We have questioned almost everyone we can find in our organization to see if there's anything that could have been determined a list, and we have not been able to find such. The only thing I can think of is that early in the examination, I told the examiners to be sure and get a full list of all of the customers of First American, so that when we had known names from the Middle East or from Europe or from wherever who were people who might be linked to BCCI, that they could check it against the full list of the customers. And so our examiners have that list. But we do not have a, to answer your question directly, I know of no list of individuals who received payoffs. I would like to have such a list,
Do you have...
and I would be happy to turn that over to the committee immediately.
Do you have any evidence of, at this point, of either bribes or payoffs? Or
We have a few instances where there are expenses paid for people to take trips and attend conferences and the like. There are some, you know, obviously any bill to a law firm, any bill paid to a law firm, you have to know what's behind that. We don't know of anything at this point. We have some list of people as consultants, really not a list, I guess 1 or 2 consultancies that you could say, what did the consultant do and so forth. But we don't have any big list of...
Well, just a last question before I turn it over to my colleague here. Are you aware of an audit completed recently by the auditors for First American which suggests that certain U.S. officials may have received unusual services or payoffs from the bank? Have you heard of that?
I am not aware.
You're not aware of that. So you don't have either of those in your possession?
No. Virgil?
I'm not aware of it, Senator.
Fine, that's fine. We've just been hearing about it, and I wanted to ask...
We have too, and we're most interested. Any information that could lead us to find such a list, we'd appreciate.
Thank you very much. Senator Brown.
Thank you, Mr. Chairman. Mr. Taylor, or perhaps Mr. Mattingly, I'm wondering if you can tell me when the Federal Reserve first had information forwarded to it that raised the question of BCCI having taken control of the bank or purchased indirectly controlling interest.
Well, we had the, I think the first indication that I had was really through a contact that our Mr. Rybeck had internationally that indicated there were loans at BCCI in Luxembourg. I mean, that was the first time I think I had heard of a specific statement. Allegations from the beginning, I mean, from 1978 on. But as far as information on someone having control and there being an identifiable individual that made that statement, I think it was probably 1989. Bill, November? November.
I think that's correct. In December, as I testified in front of the Senate Banking Committee, I'm groping here for the date.
Well, that's about 13 months prior to when the investigation was ordered?
That's till the order of investigation was given. That's correct.
What we did after we received that was you want to?
Yeah, let me back up. I mean, first of all, as it relates to BCCI and what I'll call the modern era, 86, 87 on, I mean, in 1987, of course, the Federal Reserve, through its examiner in Miami, made a criminal referral for money laundering, 1987, to the Justice Department and to the Internal Revenue Service, which was then the procedure for Bank Secrecy Act suspected violations.
I'm sorry, repeat that for me. Who was it who made the...
Our examiner, in an examination of the agency of BCCI in Miami, suspected money laundering and made, through the Atlanta office of the Federal Reserve Bank, a criminal referral to the Justice Department. I believe the procedure was that after they had made that referral, we received it in Washington at the Fed, and we were the ones in Washington who made the referral on to the Internal Revenue Service. So there were 2 referrals of the money laundering in 1987.
Was there anything in that period that was passed on to the Fed that would have suggested that BCCI had an equity interest?
Yes, there was a telephone call that a member of the supervisory staff received from a customs official on December the 27th, 1988, customs officer, asking our supervisory person about a possible connection between First American, National Bank of Georgia, and BCCI. The customs official asked for all the documents, the Y-7s, the reports, and anything else that we had. And in the course of that conversation, he mentioned to this Federal Reserve staff person that he had an indication from a BCCI employee that BCCI owned the First American banks.
What action did the Federal Reserve take when that information came to their attention?
Well, I don't know whether this was in response to that or not, but in January of 1989, the Federal Reserve Bank of Richmond conducted a review to determine whether BCCI, whether First American, whether there was a link between First American and BCCI.
So the information came in '88. In '89, they began a review.
The review did not detect that link.
You have to remember that the information that came to us was that was a statement that someone had made. There is no corroborating evidence of that I'm aware. And that the first time we found a place where there might be corroborating evidence is really when we had the supervisor in Luxembourg tell our Mr. Rybeck that there certainly are loans.
And that was when, again?
That was November of '89.
November of '89. Tell me, in the financial statements that the nominees had submitted when they acquired their interest in the banks, that, as I understand it, you all reviewed, were those consistent? I mean, were they, looking back on them, are they financial statements that you think would be reasonable for people acquiring this large an interest?
Remember, BCCI did not buy the. Our records didn't.
I understand that, but the people who were the so-called that purported to be the purchasers of the bank.
Yes, the original application, there were submitted with the original application statements by those people showing, in most cases, very, very substantial net worths.
And were those financial statements audited?
No, they were not. There were some of them that were submitted by accounting firms. There were also confirmations of account balances at banks. In addition to that, the Federal Reserve went to the point of holding a hearing and having 4 of those investors come in and testify in front of that hearing. Those individuals came in, it was an informal hearing, those individuals came in and made statements that they were going to make the acquisition with their own personal funds. They were not borrowing from BCCI.
What did the Fed do to verify those bank statements, those personal financial statements?
The staff of the Federal Reserve made inquiries of other government agencies about any information that they might have about these particular individuals. We went to the CIA, the State Department, the Commerce Department, and so forth. As I said, the financial statements that were submitted with the application, there were requirements that they also submit, in certain cases, statements from banks indicating that the banks were holding balances for those individuals.
Now, according to our press, Mr. Clifford and Mr. Altman, on about May 3rd, presented federal bank regulators with a financial statement outlining their purchase and sale of First American stock in the 1986 and 1988 period. Do you understand that to be correct? Is that newspaper report correct?
Well, the Federal Reserve did not find out, well, Mr. Altman and Mr. Clifford reported in certain of the official filings with the board by the company that they had purchased stock of CCAH. During our investigation, we found out that that BCCI, that those acquisitions of stock were financed by BCCI. And that is the report that I think you're referring to.
Mm-hmm. Now, there's a chart before you that may help it, but basically, as I understand it, the stock in a roughly year-and-a-half period tripled in value. portion of that was sold at an enormous profit, and a portion of that stock remains in those gentlemen's names.
Senator,
My question is, what's going to happen to the stock that they continue to hold, and what will happen to the stock that, or the profit that was recognized off of those stock sales?
Senator, as I indicated, the board's investigation into this matter is continuing, and I believe I would ask your consideration that we not answer that question. That is a matter that's directly involved in our investigation as well as in our investigation.
I can appreciate your position. Let me ask, is it within the purview of the board to take action regarding a stock sale and take action regarding the stock? Is that one of the things that comes under?
That would be within the purview of the board under our supervisory responsibilities. Yes.
And if I understand what you said, is these are both areas that which you're looking into?
The board is looking into the entire matter of this BCCI First American link from 1978 when it started until the present. We are looking at every aspect of that from every possible angle. And as I indicated, when we get evidence, we take action. Now, in this indictment that we issued the other day, there are schedules which set out who bought the stock, when, and for how much, and when they sold it. I can tell you that from that document, it's alleged that Mr. Clifford and Mr. Altman in a rights offering conducted in July of 1986, Mr. Clifford purchased 4,495 shares of CCAH at $22.16 per share. Mr. Altman purchased 2,247 shares of CCAH at $2,216 per share. I can also say that the notice that was issued by the Federal Reserve Board indicates that in 1987, in 1988, Mr. Clifford sold 3,200 of the shares for $6,800 a share. Mr. Altman sold 1,600 of his shares for $6,800 a share.
Thank you. One last question, if I may, Mr. Chairman. I'd be interested in knowing your view as to whether or not it would be of value to ask for audited financial statements from individuals when they are making applications. Wouldn't that have solved some of this problem?
Not if they were the kind of audits that were done of BCCI.
Well,
I mean, we oftentimes find, the serious answer is that we oftentimes find that an audited statement does not necessarily give you the picture that you would expect it to. And it's sorely disappointing that that happens as frequently as it does.
well, I can appreciate if you're talking about an international bank, but if you're talking about an individual financial statement, surely if someone's dramatically misrepresented their net worth, an audited financial statement is of great value, isn't it?
It certainly doesn't hurt a thing. It certainly can't detract, but I mean, it is not necessarily a comprehensive statement of truth, unfortunately.
But I guess I assume, without knowing the substance of those statements, if someone showed the ability to buy hundreds of millions of dollars worth of stock, and it turns out they have nothing in the way of assets, a basic check of those financial statements could have turned that up, couldn't it?
Senator, that's exactly why the Federal Reserve requested detailed financial statements. The individuals, these Middle Eastern investors who the Fed was told were going to buy this stock their statements show that they are wealthy. There are a number of them who are rulers of Emirates, of the United Arab Emirates.
One last question. My understanding, Mr. Clifford is the chairman of First American, and Mr. Altman is its president. I also understand that you have the authority or the ability to remove them or replace them with officers or directors that are not tainted by connections to BCCI. Is it your intention to exercise that authority?
As I indicated, Senator Brown, the board's investigation is continuing, and when we obtain evidence that indicates that enforcement action should be taken or is taken, we take it. Other than that, I really would not like to comment on the status of the decision-making going on within the Federal Reserve about what specific additional supervisory actions should or could be taken next.
But that is within the purview of the board.
The Federal Reserve Board has authority under the statute to remove a director or an officer of an American bank or bank holding company if it meets certain tests. There has to be a violation of law, damage to the bank, and so forth.
I might add, not as it relates to this case, but the removal of an officer from a U.S. bank is no easy task. It is very difficult in a legal sense to do that, and in fact, we have offered corrective language, have we not?
We have proposed corrective language.
What, if any, action is the Fed taking to protect records and guarantee that records are not destroyed?
Senator Kerry, when we commenced our investigation, one of the first things that we did was take physical possession of every piece of all of the CCAH records that we could get our hands on. Now, there are certain records that we have not yet been able to gain access to because of claims of attorney-client privilege. There were procedures put in place, however, to safeguard those documents. But when anyone told us of documents, we acted. When we were told that there were records at the Miami agency that were useful for our investigation, we issued a subpoena, and we have thousands of boxes of documents from the Miami agency under subpoena. When we are told of information, we go after it.
Senator Cranston.
Thank you very much, Mr. Chairman. Am I correct in my understanding that BCCI has or had representative or agency offices in D.C., New York, Miami, San Francisco, Los Angeles, Boca Raton, and Tampa?
Senator Cranston, they had offices in those cities. Some of in Washington, D.C., it was what's called a representative office, and in Houston, it was a representative office. In the others, they were agencies.
Are they still active and open?
They were, on July 5th, there were two left. There was one in Los Angeles, and there was one in New York, and both of those were seized on July 5th by the state of California and the state of New York.
What about the agencies?
Those were agencies.
Those were agencies.
Those were agencies. And I understand, I mentioned this morning some banks with some sort of relationship in some other states, or in addition to those we've been discussing. One is the former Bank of Commerce, now First American in New York. In Florida, the former Bank of Escambia, now First American, Florida. In Maryland, former Financial General, now First American, Maryland. In Virginia, former Financial General, now First American, Virginia. And in Tennessee, First American. First, am I correct in my understanding that these are not connected with First American here in Washington?
No, they are. First American here in Washington, D.C. owns most of the banks directly that you named. They own a bank in D.C., a bank in Maryland, a bank in Virginia, a bank in New York, bank in Tennessee, and a bank in Florida.
Is that within a holding company?
Yes,
structure?
It's a holding company, and they own subsidiary banks.
Regarding the Independence Bank of Encino out in California and part of Los Angeles, does or did Gates Fayron own the Independence Bank?
Yes.
Yes and no.
The bank was bought in his name. We allege that BCCI used Mr. Ferrone as a nominee to purchase the bank.
Is he still the owner?
He is the record owner.
What's the current status of that bank?
That bank is under a divestiture. BCCI is under a divestiture order from the Federal Reserve to dispose of that bank as promptly as possible.
Have there been transactions between Independence Bank and the BCCI office in California or with other BCCI institutions?
The Federal Reserve order, we issued an order against BCCI in connection with the independence matter in May of this year, and that order was intended to terminate the transactions between the bank and the BCCI. There were some transactions, however, between Independence Bank, I believe, and BCCI's operations in the United States. Those transactions are being looked at by the Federal Reserve.
Were any former BCCI employees employed by Independence Bank?
Yes, and there was a BCCI employee named, yes, it was a BCCI employee who, our information is, negotiated the acquisition of the Independence Bank and then was, our indictment says, was then put in as the chairman or chief executive officer of Independence Bank. The Federal Reserve has issued an action barring that person. He's no longer at Independence Bank, but there's an action outstanding to keep him out of U.S. banking in the future.
Keith Farron, while owning the Encino Bank on behalf of BCCI, also helped BCCI acquire 25% of SunTrust in Florida, according to the Federal Reserve order of July 29th, which just came out. Can you tell us how and for what purpose Farron and BCCI obtained an interest in this failing S&L?
Senator Cranston, the Federal Reserve, the focus of the Federal Reserve's investigation has been on the First American organization. In the course of that investigation, we come across other information that BCCI has acquired banks, and we act on it. In this particular case, the SunTrust Savings Bank in Florida, we came across that within the last 3 or 4 weeks. We found some documents in London that indicated that in fact, BCCI had funded Farron's acquisition and that the shares had been placed or pledged to BCCI and that BCCI had voting control over those shares. I cannot answer your question about why BCCI acted in that way.
Regarding First American here in Washington, does the Federal Reserve have any questions about whether officials of the government of Abu Dhabi may have violated U.S. laws in acquiring the bank?
Senator, again, the board's investigation, as I indicated before, is looking at all aspects of this thing, and as we get evidence, we act on it. The indictment that the Federal Reserve issued on July 29th does not charge the government or ruling family of Abu Dhabi with acquiring illegally control of First American.
But that may be a matter that's being looked at. Is that correct?
We're looking at all matters in connection with this case.
What's the current financial status of First American? For example, has new capital been placed in First American in 1991?
That's correct.
Can you tell us by whom and how much?
Yes, the Abu Dhabi government and Abu Dhabi Investment Authority and Abu Dhabi ruling family since let's say September of 90, within the last year, has placed approximately slightly over $200 million into First American. Some of it to deal with debt at the holding company level, and some of it to put into capital of the subsidiary banks. Basically, what happened in the beginning of the year is we asked the other agencies, the Federal Reserve is not the primary supervisor of any of these banks, but we asked and received the cooperation of the other supervisors, the controller, the FDIC, the various states involved, and they have examined the bank. And what we did was go to the Abu Dhabi people and say that the capital requirements of the supervisors are X, and we expect you to put that in there. And they did, and a little more, actually. And so they've been fairly cooperative, even though they fully understand that they're under, that the whole thing is to be divested ASAP.
Do you know if any commitments were made by the U.S. government in return for this infusion of capital?
None that I know of, and I'm the one who asked for the money.
Mr. Taylor, you mentioned in 1987 criminal referral by an examiner.
I'll let you just for a minute, because we're trying to cover some logistics here. We're almost at 4 o'clock, and we haven't had the State Department folks on yet. What I'm going to do, with the permission of my colleagues, is suggest that we put states' current statements in the record as if read, but not proceed forward to question them today and build off those and have them back at a time when we have more time to pursue those questions. Because I think there are going to be limits to what we can digest, and we do have we want to try to deal with the issue of Peru and so forth. Is that agreeable? Fine. I'm sorry to interrupt you.
Mr. Taylor, you mentioned in 1987 criminal referral by an examiner to Justice Ray, BCCI, and money laundering. Do you know if that led to a criminal investigation?
I do not. I know that a criminal investigation resulted within a year after that. I think it was in April of '87 that the referral was made, and the raid in the Tampa situation occurred in October of '88, I believe, approximately 14 months later.
Mr. Manley, you mentioned a criminal referral also. Was that the same one or a different one?
No, I mentioned, the criminal referrals that I mentioned were with respect to when we obtained evidence in January that suggested that there was a illegal acquisition by BCCI of the First American organization, the CCAH stock. We made criminal referrals to justice in connection with that.
Do you know if that led to a Justice Department criminal investigation?
I'm not at liberty to.
Back to the matter of the infusion of capital. When did the last capital come into First American?
The last capital came into First American, I believe, in June, the first or second week.
Last week in June.
Last week in June, was it? No, it was either mid to late June. Just prior to the closing, I might.
Was that a large infusion?
No, I believe it was the capital that went into the banks was something on the order of $39 million, pretty sizable. And of course, at the same time, I believe the Abu Dhabi people assumed the holding company's debt, which was somewhere on the order of magnitude of $80 million.
In addition to the several banks that I mentioned and you've verified have been owned or affiliated with BCCI in the United States, do they own or control any businesses beyond that in our country?
Not that I'm aware, Senator. Virgil probably has more from the investigation than.
Senator, I don't think the investigation has turned up any evidence of that, but, according to the reports they filed with the Fed, they didn't own any banks in the U.S. either, and one has to question their credibility on all points.
And that wouldn't be a thing that you'd be looking into as much as you'd be looking into financial institutions.
Our investigation, it's difficult to keep it focused, but our investigation is directed and focused at those banks. But to the extent that we get any evidence of any other illegal conduct or suspected illegal conduct, we make appropriate referrals.
Mr. Chairman, I have just a few more questions, but my time is up. That's it.
Well, let me just see. Senator Wofford hasn't had a chance yet, then we'll come back to you, Senator Cranston. Senator Wofford?
I have, I think, simple questions. Did the CIA ever tell you that BCCI owned First American?
Senator, I do not believe so. We have, as you can imagine, we have searched our records. There is no indication that that information was conveyed to the Federal Reserve. I have asked the individuals at the board who routinely receive information from CIA. They indicate they do not recall ever seeing that document. They believe they would have recalled seeing that document if it had in fact been submitted to the Fed.
Did the Treasury Department ever tell you that BCCI owned First American?
Senator, I can only speak for myself. I have reviewed the record in this matter, and it is voluminous. I find no evidence that that the Treasury advised us. I cannot say that they did not advise some other official who did not make a note of it, and I just can't say.
Yeah, by you, I meant you and the corporate body too, so I appreciate that.
Well, I'm looking through the records. We look through the records. We can find no indication that that information was transmitted to us.
Do you think they were obligated to tell you?
I would hope that when any American or U.S. agency finds information about irregularities under the Bank Holding Company Act or the statutes that the Federal Reserve administers, we would hope that that would be referred to us. We try to do the same when we come across information about irregularities involving other agencies.
My understanding, though, is that the information in the CIA report is more or less speculative in the sense that it's not documented with any evidence that you could follow up on. That it makes the assertion, and we've had that assertion, but it doesn't.
Well, the assertion, I think the CIA document, if I recall correctly, I don't have it in front of me, states as a matter of fact that they tried to buy the bank shares in 1982, 81, were rebuffed, but completed the transaction and takeover, as it states it as a matter of fact.
6 months later, right?
6 months later, it says this was completed. They say, the one thing they do say is we don't know the exact structure of ownership, but they state as a matter of fact it was completed and it was purchased.
Yeah, and that may have been helpful in the sense of alerting us.
May I say also that I have seen the entire rest of that document, and as I said earlier, I cannot understand, there is no national security in it whatsoever that this senator can see, and I think the entire document ought to be released, and we're going to ask for it.
I appreciate the chairman, Senator Kerry's helpful persistence right now, but most of all the persistence in getting at this matter, which turns out to be a persistence that was well justified. Could I turn to the procedure by which the Federal Reserve checks the background of foreign investors?
Yes.
With the CIA? And forgive me if you have gone through this before I was able to get here. Could you just take us through that procedure and show us what the paper trail would be in checking the background of foreign investors with the CIA?
Well,
once again?
In this particular case, as it stands now, we check foreign investors with law enforcement authorities, the DEA, CIA, FBI. There are detailed procedures to do background checks on any foreign individual or company that seeks to acquire an American bank. In this particular case, the information that we had, which listed 10 or 13 Middle Eastern investors, was sent to State Department, CIA, Commerce, at least those three. And we received back no adverse information from those three agencies.
So that you didn't have that, and therefore you didn't take any action?
No, we got back affirmative responses from the CIA and the State Department that they had no objection, no adverse information.
No more questions right now.
I want to ask you just a few questions about central banks and their problems out of all this. Has the Federal Reserve learned of the use of BCCI by any foreign central banks?
We don't. We have various reports of use of BCCI by central banks. For example, not necessarily central banks, but by governments in the sense of the Peruvians have been up to see us about that situation, and there are other rumors about various developing nation banks being involved with BCCI. As yet, I don't believe they have documented that the receiver or any of the Bank of England people have documented any specific deposits or losses to date by central banks, although it indeed may be in the works. Is that a fair?
What are the implications of this for foreign central banks with this sizable deposits with BCCI, and what are the implications for international financial markets?
Well, I think the thing that has been almost deafening is really the lack of specific information yet as it relates to any major loss. In other words, a loss that really would take some large bank or country or charitable institution down. We think that most of the central bank activity, we are just not aware at this point of anything that has any dramatic impact as yet, although all of this is unfolding, and I would underscore that we watch it day by day, and when we make these statements, we might indeed be forced to make another statement the next day.
Senator Cranston, I have some information from the board's legal files in response to the question that Senator Wofford asked, and if it's permissible, could I read that into the record? This has to do with the Federal Reserve's background checks of those individuals in 1981. Board staff has consulted the Central Intelligence Agency and the Departments of State and Commerce to determine if they possessed any information that would have any bearing on the integrity of these individuals and the other investors, or that would suggest that they should not be permitted to be associated with a U.S. banking organization. Board staff was informed that the CIA has no derogatory information in its files, while individuals consulted at the Departments of State and Commerce stated their belief that there is no reason why the investors in CCAH and CCI should not be associated with a U.S. bank.
Ray.
That's what year? That's 1981?
Yes, sir.
That's 1981. And that is referencing specifically Sheikh Zayed and other...
Sheikh Zayed was not an investor in the original application, but it did...
Kamal Adham?
Yes.
All right, that's Kamal Adham and company at that point in time?
Yes.
Would funds deposited by a central bank in any country with BCCI...
Wasn't he the former head of, chief of Saudi intelligence?
That's as reported, yes.
Would funds deposited by the central bank of any of these foreign countries with BCCI be guaranteed in any way?
Not to our knowledge. I mean, guaranteed by, not to our knowledge.
I mean, they may, in some cases, have been wise enough to take collateral and maybe not, and in that sense, they would have a chance of a prior lien, but we are not aware of any insurance specifically.
One final broader question. You spoke of the legislation that Senator Regal, Senator Garr, and Senator Kerry have introduced to try to prevent things like this from happening in the future. Obviously, we have to give that a lot of scrutiny to make sure it's as strong as possible. And the hearings there in the Banking Committee now going on, or markup there and hearings here will lead, I hope, to strong legislation. But let me ask this question. Can any American laws that we might write really deal adequately with what is an international problem? Or don't we need to take a look at what strengthening of international regulatory institutions may be required to really cope with this kind of a situation?
Well, I think clearly it is, I mean, your question is, in a sense, rhetorical, and I agree with it. Obviously, we must do something internationally, that we can't just pass laws here, although it would be helpful in certain instances. But internationally, I think it's very critical that we create, I think, as indicated by prior witnesses, a greater sense of cooperation and information exchange and a certain setting of standard. We've started that process in a number of areas through the Basel Committee on Banking Supervision that meets at the BIS. We meet there quarterly, and although sometimes it seems that progress is painstakingly slow, there have been very encouraging instances of breakthrough in recent years. I point to the capital agreement, whereby we finally got an agreement that somewhat defines capital and says how much banks should have to operate internationally. We had some success in an American-sponsored approach to money laundering, whereby it was recognized by the member nations and the member central banks that using the banking system for illicit purposes was something that no one sponsored. And indeed, I think in the European countries that have reputations for secrecy, you see that secrecy perspective lessening, and you see more open philosophies, and you see more states in Europe sponsoring legislation against money laundering in favor of an openness that protects the banking system and the public from these criminalities.
I thank you both very much. You've both been very helpful, and I applaud your direct, concise, and brief responses to our questions. Thank you.
Senator Kassenbaum.
Thank you, Mr. Chairman. My apologies. We are marking up the banking bill in the Banking Committee, but I was anxious to come down for just a moment to ask the representatives here of the Federal Reserve, particularly a question in response to a letter that I'd received from a constituent regarding the BCCI settlement and the whole plea bargaining relationship. I bucked the letter over to the Department of Justice. And the letter I got back had a sentence which I thought was interesting. And if I just may read that sentence. Moreover, the bank has been placed on a 5-year probationary term which contemplates intense scrutiny of its activities by the Federal Reserve Board of Governors. Should BCCI violate its probation, the trial court could fine the bank $500,000 for each violation. I guess at that point, I would be curious with this plea bargaining arrangement, which I'm not really familiar with other than as it's begun to unfold in recent stories. Did it trigger any sort of additional activity on the part of the Federal Reserve, or would you normally be involved in a situation such as this?
Well, I'll tell you what I know about that, Senator. The plea bargain that was negotiated between the Justice Department and BCCI, I believe one of the provisions, Senator Kassenbaum, as a result of the indictment, the Federal Reserve issued a cease and desist order in mid-1989 against BCCI, requiring them to put in, their management and procedures were abysmal here in the United States. And so the Fed put in a cease and desist order requiring them to clean up their act, have appropriate books and records and things like that. And that was, I believe that was done in June of 1989. The Justice Department then when they had their plea agreement and conviction or guilty plea, they incorporated that order into that and therefore required BCCI to comply with the order through that mechanism also.
But we were not a part of the plea bargain at all.
No, I realize that, but they
knew that we had this cease and desist order. And they just simply incorporated in their plea agreement a requirement that BCCI obey the board's cease and desist order. And if they failed to obey it, then they would be subject to the fines that you mentioned.
Yeah, immediately upon the sting operation in Tampa, as soon as that happened, in conjunction with the states, who were really the primary supervisor of these agencies, with their cooperation, the Federal Reserve and the states immediately examined all of the agencies in the United States of BCCI to see if there was any more money laundering and to see if they were complying with reasonable procedures. As a result of that, the additional criminal referrals were made out of New York, and the cease and desist order was issued to correct what we thought were rather substantial deficiencies in the record keeping and in the controls.
Was it that cease and desist order, and you say that was June of *89?
I believe
you first
that's
entered
correct.
That?
June of '89?
It didn't seem to have much effect, did it, at that point?
No.
Or did?
I mean,
well, I came in late, and I suspect you've covered a lot of this territory, and I don't want to keep you here any longer, but I do appreciate the answer to that, and I regret that I came so late because I would have liked to have heard some further. I'll read your statements. Thank you.
Thank you, Senator.
Well, I'm out. That's
Thank
all right.
you.
I don't want to keep you long.
Thank you very much. First of all, let me ask just a few questions before we wrap up. You hear varying amounts of money that are supposedly just gone. In England, they're talking about $5–6 billion, maybe more. We've heard $4 billion to $8 billion. Some people say more than $10 billion. Is that correct?
all of those figures are correct as far as I know. It's very hard to get a sense of where it starts and where it stops. I think only when the liquidator really gets a chance to see what is there and what isn't there will you have any accurate figure. It's pretty safe to say from the statements that I've seen that there is massive fraud involved. And massive fraud would mean massive money. Whether it's 5 or 10, hard to say.
Well, where would that I mean, do you have any indication of where that, the money that we do know about, whatever concrete number there is, I think one of the complaints alleges $4 to $5 billion. Where is that? Where'd it go?
We would love to know. That is the unanswered question in this matter, and is where did all of that money go?
There are
But there's no
clearly,
doubt that it's gone somewhere.
there are clearly loans that have been made that the accountants feel are not repayable, and those are substantial. Some to various types of companies, shipping companies, real estate interests, oil, whatever. But I mean, it is not a case of, I mean, there may indeed be basic fraud, but there is also lending problems where the loans are overvalued on the books.
Were they overvalued on the books as part of the scheme to enrich people, or were they overvalued because these people were doing bad business?
It might be a bit of both. It's clear they were doing very bad business. I mean, they were, from what we've been able to see, everything they touched turned to a loss, and they had to cover those losses up. I mean, this is a bank that showed profits. Its reports that were filed showed profits every year. They weren't, the profits were, you know, our evidence suggests...
Well, you've talked about sham transactions with respect to the purchase in Washington, D.C.
Correct.
Do you have evidence of other sham loans?
Senator, those are the ones that we're looking at. We do not have any direct evidence of other sham loans.
Well, isn't it true that the Price Waterhouse report, which you're going to deliver to us very shortly, is indicative of that kind of...
I think the Price Waterhouse report will show you, where some of the bad loans, show you names of bad loans and so forth. But it is not in sufficient detail to really give one a grounding in what the loss amount is.
Now, with respect to that, this is the report that triggered the closing, correct?
This is the report.
This is the report by the hired auditor. You're saying it's not sufficiently detailed?
Well, I'm
to be
saying...
able to tell you what happened, yet it's an audited report?
No, I think it's sufficiently detailed to, I mean, one of the statements in the report that captures your attention is one that says, we cannot put a balance sheet together on this bank, so we don't know what it has or what it owes to who.
Yeah, well, don't you think it'd be interesting for Price Waterhouse to come in here and explain its auditing procedure on this bank?
Well, I think what they found, and I think it was really quite, I mean, it's quite a courageous audit report. It says that...
Well, let me ask you about that. It conducted an audit report how many months prior to that?
I think the last statement was 89, so that would have been 50.
How about October 90?
There was a statement that was the critical statement that I discussed in my testimony, October the 3rd, 1990.
And prior to that, there was 189. Well, what happened to Price Waterhouse that suddenly, between 1989 and 1990, they noticed their figures were wrong?
I would have to say that it is a good idea to get Price Waterhouse in here. Let them explain it.
Now, what are the foreign implications of the central bank infusions that we are learning about in this? Are there implications? I mean, in Peru right now, there's a lot of question. We're going to be hearing from witnesses, probably tomorrow morning now, the way we're going, but who are going to describe some of the problems down there. We've got problems in Nigeria, we've got other countries that are reeling from this. Are there implications for us in that context?
Well, I think there are implications to the extent that turns out to be the case, and it's material enough to adversely affect those nations' central banks' ability to carry out their mission. We just don't know if that's the case as yet.
Okay. Now, Mr. Mattingly, at the last hearing we had, I asked you questions about Mr. Adham, and we just talked about it briefly. Mr. Adham, who was one of the original CCAH shareholders, was a former head of Saudi intelligence, and that was known at the time, correct?
That was reported at the time, yes.
That testimony will incidentally be placed into the record in this hearing, but did anyone advise the Fed that another original investor in CCAH, Mohammed Irvani, was funding former CIA Director Richard Helms's Washington consulting office. Were you aware of that?
Senator, I have looked through the records. I have seen no evidence of that.
You've
I've
seen
seen
no
no
evidence
evidence that anyone reported that to us.
that you knew of it then. Did the CIA advise the Federal Reserve that Adham had employed agency personnel in his business ventures?
Agency personnel, CIA
Correct.
personnel? No, sir.
Okay. After the 81 takeover, was the Federal Reserve ever advised by the CIA or the State Department or the Treasury Department or the Justice Department that First American was owned by BCCI? Did any one of those entities ever advise you formally or otherwise?
I have no record of that. And we've searched the record, and we'll continue to search the record.
What would the format be for such notification?
I
I mean,
assume
would you get a letter? Would you get a mail? This was pre-fax, I presume?
pre-fax, yes. It would probably have been a letter or or some sort of memorandum that would be submitted to the Fed, yes.
And normally, when a matter is called to your attention of that import, that is the normal process. Is that correct? The customary business procedure, as we say?
Yeah, once again, I mean...
And those records have been checked, and there is no record at the Fed Reserve of any notification of ownership.
I know of none.
By
Treasury,
Treasury?
CIA,
Treasury,
Justice.
CIA, State Department, or Justice.
Treasury, CIA, Department of Justice, State Department. Certainly not CIA until
recently.
until very recently.
Everybody now seems to know it. I mean...
Senator,
Chagrin.
to the best of my recollection, no, not from those.
Well, you want to go back to the record one more time and just be certain?
I will.
Let
I'm
us
happy to
know.
answer that for
All
the
right.
record.
Now, on page 2 of the July 29th press release announcing the civil money penalty, you make the following statement, quote, "At the request of the U.S. Attorney for the District of Columbia, the Board has deferred temporarily the assessment of substantial civil money penalties against individuals pending completion of the U.S. Attorney's criminal inquiry." Did you meet personally with Jay Stevens regarding that?
No, we did not. Obviously, the Federal Reserve does not want to take any action or to do anything that would interfere with bringing the responsible parties to justice.
I understand. But did you make a judgment? Did the Federal Reserve make a judgment that it wanted to impose civil penalties, but that you were told by justice that might interfere with the criminal process?
Senator Kerry, we sent the notices over to the Justice Department. There were civil money penalties assessed in the draft notices. The Justice Department said that there were legal problems with the Federal Reserve. There could be legal problems with the Federal Reserve proceeding to assess civil money penalties, that the civil money penalty assessment could preclude subsequent criminal prosecution of these individuals, and the Justice Department...
What's the theory of law on which that is based?
There is a Supreme Court case that came down, maybe it's 2 years now, Halper, the United States versus Halper, which indicates that under certain circumstances, may indicate that under certain circumstances, a civil penalty or a civil penalty could be so substantial that it could be punishment and trigger the double jeopardy clause.
Okay.
And that the Justice Department hasn't made any decision on that, of course, but they are looking into that question, and that is the reason for this.
No, fair enough. I just want to understand it, and that's, I accept that. Did you meet with anyone at Justice Department in the course of the last couple of months regarding this matter?
We've had a number of meetings with Department of Justice personnel about this investigation, yes.
Beginning in what period of time?
Oh, right after the criminal referral, we met with I met with the U.S. attorneys assigned to the case. The actual attorneys who are investigating this matter have met on any number of occasions with Department of Justice personnel about this case.
Now, Mr. Mattingly, I know you've been very cooperative with the District Attorney in New York, and we went through the issue of cooperation last hearing. This may be a hard question for you, but I'm going to ask it. Has anyone at Justice Department suggested to you you should cooperate more with them than with the District Attorney in New York?
No, sir.
That's never been suggested to you?
Not to me.
What about any of your investigators?
I haven't had that brought to my attention.
When asked on, well, let me ask you this, the complaint that you issued the other day suggests that makes several references to the fact that BCCI owns SunTrust Savings and Loan in Florida. When did the Fed learn of that connection and how?
Our investigators were in London trying to get documents. We were going to interview some witnesses. It was 2 or 3 weeks ago. Interview witnesses and obtain documents with respect to the illegal acquisition of National Bank of Georgia. When we looked through some documents that were seized from BCCI's offices, we found documents in there that I described that indicate that BCCI actually had a substantial interest in SunTrust. If I could, about the Justice Department, one comment. I mean, we did go to them with this last civil money penalty of $200 million, and they gave us the green light to proceed with that. I want that on the record. I would like to put that on the record.
To proceed with the civil penalty?
Yes, they gave us a green light to go ahead and assess the $200 million civil money penalty against BCCI.
Did they think it was a little steep?
They did not convey that to me, no, sir.
Do you have any evidence that the shredding of documents or destruction of documents that Mr. Blum referred to earlier in fact has taken place? Is there any way for you to determine gaps in the records you have or partial?
With the seizure of the New York agency on July 5th, we commenced inquiries to try to locate the files at the Washington, D.C. representative office. And the state of New York has taken action to secure those, as has the county attorney in New York, and I believe the Justice Department also.
Does that mean that you're having difficulty doing that?
I don't know what the current status of that was. I'm informed it's been done.
It's been done. So those have been secured in full. But you don't know whether or not some documents are missing or not missing?
No, sir. I do. No,
you have no way of telling.
We have not had a time to go through those files. We certainly intend to do so. I might add that the California authorities have also seized the files at the Los Angeles agency, and they are in the process of going through those records to determine what is there.
Okay. Well, let me say that I'm going to move on here. There are some sort of housekeeping areas of inquiry. There are a lot of detailed questions that we don't need to go through right now, but we would like to leave the record open so that some of those can be asked. We've been at this for a long time, and I don't want to. I think people are getting a little bleary-eyed. I know this senator is. Senator Jeffords, do you want to inquire for a moment?
Just a moment, yes. If Senator Cranston wants to go ahead, he was here ahead of me. Fine. The New York grand jury indicted BCCI, I think it was count 4, for grand larceny committed against the American Express sometime after January 1st, 1983. When did the American government discover that American Express was a target of criminal activity by BCCI? Do you know?
Senator, the first that we heard of that was in the indictment. The first that the Federal Reserve heard of that was when we received a copy of the indictment.
Do you know of anyone else in the government that had prior notice?
I do not, sir.
I believe you testified earlier about some activity in the international scene which is going on now with respect to looking at how to prevent further occurrences of such things. I think you talked about some money laundering discussions and matters like that. Is there any other meetings or discussion going on as to what ought to be done at the international level to try and make sure that a BCCI does not occur again?
Yeah, I think first of all, the Basel Committee continues, as well as the European group, the EEC group continues, which is another bank supervisory group. And I think that there are efforts underway there, and I'm sure that when this BCCI thing is fully out on the table, the committee will both committees will look at it and try to take what actions are appropriate. I think it's very significant, at least from a U.S. perspective, that we're very happy to see the chairmanship of the Basel Supervisors Group pass to Jerry Corrigan at the Federal Reserve Bank of New York. He will chair that committee. In fact, he has been voted as the chairman. So the U.S. perspective will get a clear statement from the chairman's seat.
Well, would they be looking, would that be the kind of a group that would be looking at international mechanisms to be able to observe what's going on and have regulatory authority in the international sector or things along those lines?
Yes, I think that in the Basel Supervisors Group consists of 12 countries, the 12 major industrialized countries, and those representatives at that meeting are basically central banks and bank supervisors, and they have authorities in their own countries and have powers in their own countries to make these kind of coordinated arrangements work. So it is the right body to be working with. Sometimes some countries will have to go back and get their law changed, but I think there has been progress, especially on money laundering, and I don't think there's anyone on the committee that feels anything else than the banking system shouldn't be used for criminal purposes at all, and is prepared to do what's necessary to make sure that doesn't happen.
I might just add a footnote to that, Senator Jeffers. The banking bill that's being marked up today has a provision, an important provision in it, that provides that if a foreign bank wishes to do business, that the board cannot approve additional offices for foreign banks in this country unless the board is satisfied that the foreign bank is supervised on a consolidated basis by its home country.
Would these kind of mechanisms provide the ability to monitor the transfer of funds from country to country?
Well, I think that's one of the things that is being discussed. The whole question of the safety of the payments mechanism, so not just the potential criminal use of it, but the effect of that criminal use should you have some kind of a blow-up. In other words, would you in effect stop the capacity of the world to clear its transactions? So there's not only the interest in excluding the criminal element, but there's also the self-interest of the system itself that only if the participating countries respect the system will it function properly. So I think it's probably an area that needs work and should receive attention.
I'm concerned about the shell game type of situations that we saw with BCCI and how they may or may not be criminal. You can't really tell, but unless you're able to monitor a pattern of activity and those kind of things, and I would.
Well, I mean, over the years in banking supervision, we've had the same problem domestically in the sense that you see someone abuse a bank in North Dakota and all of a sudden you find them down in New Mexico doing the same thing. And it's a sore disappointment to the examination business to ever allow that to happen. I think that systems, and especially the electronic progress, is coming to the point where I think that type of thing is going to be much harder to do domestically and much harder to do internationally. For example, we have a criminal referral system now among the agencies whereby we plan to have all criminal referrals exchanged so that there's an automated record, not just so that we have all the paper, but so that we have access to the paper and so that we can type the name into the computer and have it tell us if anything exists, as opposed to just seeing boxes and boxes of file cabinets. And I think that type of thing is also working internationally.
As I know, I mean, we've got the international stock markets and futures markets and everything else operating, and I just concerns me as I see that expansion as to how in the world we're ever going to know what's going on. Thank you. Thank you, Mr. Chairman.
Gentlemen, thank you very much, Senator Jeffers. Just before we wrap up here, has anyone at any level, to your knowledge, in any way, at any time, tried to interfere with the regulatory efforts of the Federal Reserve?
No, sir.
Mr. Taylor?
No, sir.
And Have you come across any evidence in the course of your investigation that indicates that anyone at any time, anywhere, has tried to interfere with other regulatory efforts in other states or even within the law enforcement regulatory efforts?
I can't think of any offhand, no, sir.
I can't either.
Do you concur with the judgment of the committee that there is a legitimate concern with the change in the financial marketplace and the potential for criminal elements to move money as easily as they can and to create cardboard cutout entities which mask true ownership and which, in a sense, threaten law enforcement's capacity as well as the sovereignty of some governments? Is that a concern to the Federal Reserve?
Absolutely.
Absolutely.
Is it your sense that we should be doing more with respect to money laundering and the tracking of the origin of funds?
Yes, and I
that
think
runs up right up against the bank secrecy that has pervaded the system for these last 60 years or more, does it not? 90 years, maybe?
But I and a lot of my colleagues around the world in supervision feel that it's absolutely essential that that secrecy, no matter the respect for privacy, that there must be a way to stop the criminal element from using that as an excuse to just launder money. So we fully concur with the committee on that.
And is it fair to say that it is more than simply laundering money, but that it is a really false facade of business, that in some cases is not laundering money, but is legitimately moving money into concerns? I mean, it's what used to happen here in this country with organized crime, but now has far more ways of moving that capital. I mean, isn't it really...
It's the whole scope of illicit activity, Senator, I think, that really has to be looked at, not just money laundering.
Can that be done without multilateral protocol?
I think it would be difficult to have any, to participate in the world financial community while trying to do that just in isolation. I really think you must have a multilateral approach to it to be effective.
And is it not also fair to say that the G7 at least, maybe G15 or something, but G7, G5 certainly have the ability, because of the power of their currencies and the need to clear through their systems, to leverage the Cayman Islands, Luxembourg, Hong Kong, and various other places into a stronger standard of behavior?
I think it's quite possible that also leveraging a stronger sense of behavior within their own countries.
Why don't we do it? Why isn't it happening?
Well, I think that although, as I said, it looks painstakingly slow, I think that the mechanism is in place and there can be an effective multilateral effort through Basel. There has been on some things, and this just needs to have a priority.
Before we wrap up, we have legislative friends here from Peru, and we have officials, previous officials from Argentina and Peru, and they've waited very patiently all day, and I appreciate that. Our interpreters who are going to be necessary for this have also waited all day, and I think they would prefer if we went over into the morning. I just want to make certain that it's available and clear. So I think what we will do is take that portion of the testimony in a very brief session tomorrow morning at 10 o'clock, and if there are...
And then at 9:30, you'll hear from Republican Representative Christopher Cox of California. He was the guest Thursday at the Young Americans for Freedom conference entitled Victory Over Communism. And finally, we'll bring you live coverage of the House of Representatives at 10 a.m. Eastern Time. Members are trying to complete work on a number of measures before they adjourn for the August recess. It's possible that they'll take up legislation on unemployment compensation. And that's a look at some of what's coming up overnight here on C-SPAN.
Friday, Democratic presidential candidate Paul Tsongas is the guest on our viewer call-in program. The former senator from Massachusetts will discuss his bid for the White House and the key issues facing Americans in the 1992 elections. Phone in with your questions and comments. Friday beginning at 6:30 p.m. Eastern Time, 3:30 p.m. on the West Coast.
The first candidate's announcement, a caucus in Iowa, the National Party conventions,